Hello everyone, I am Shivantika, legal intern at LEXIS and Company for the month of June, and today we'll understand cross-examination of the witness under the Indian Evidence Act. The Indian Evidence Act basically empowers and allows the examination of the witnesses and state that it is an integral part of the criminal trial. The witnesses' testimonies are one of the most important and reliable evidences because the person giving the statement has personally witnessed the event happening. This all is elaborated in section 135 to 165 of the Indian Evidence Act. It deals with examination, cross-examination, and everything. So let's understand what is the admissibility of these evidence. So section 5 of the act states that the evidence is admissible only when it is supported with relevant fact in issue. So also further in section 136, the judge may ask the parties if the evidence they have adduced deals with the relevant fact or not. And now we'll discuss the examination order. The witnesses are required to answer the relevant questions presented to them. A question asked to the witness must be relevant to the fact in issue and must help them establish the same. So their answers which recorded are called as testimonies of the witnesses, and the questioning of the witnesses are recorded, and their answer is called the witness examination. So let's come to examination of the witnesses now. So examination of a witness is the asking the witness a question regarding the relevant facts in the case and recording the statement of the witness as an evidence. So there are three parts to the examination of a witness in section 138. First, that the party that is called for the witness examines him. This process is called the examination in chief. Okay. It is mentioned under section 137 of the Indian Evidence Act. After the completion of the examination in chief, the opposition party, if wants to, can take over the witness and cross question him about the previous answers he gave, the previous statements he made. So the opposite party may ask him any question regarding all the relevant facts and not merely fact discussed during the examination in chief, and this process is called as the cross examination, which is mentioned under section 137 of the act. And the parties also have an opportunity to re-examine under section 137 itself. Okay, the parties can call the witness and see if there is a need to examine the witness again after the cross-examination. They may do so. Also, if no relevant facts are answered by the witness or there is no credibility to his statement, his testimony can be rejected and there is no need of cross-examination if in the chief examination such is not established. Okay, under section 139 of the Indian Evidence Act, it states that apart from witness testimonies, there are a number of other form of evidence that are also admissible in the court of law. Example, the documentary evidence described under section 3. Okay, a person might be called just in order to produce a document. Section 139 of the act also states that such person is called for producing the document, does not himself become the witness. Alright, section 140 of the act states that talks about the character of the party. Of someone refers, the character refers to the quality of the characteristics that distinguish them, especially their mental and moral characteristics. It also includes the reputation of the person in the society. The section states that the witness to the party's character can be cross-examined if in the examination as chief has already been completed, the evidence of character is helpful to assist the court in determining the value of the statements given by such witnesses. All right, that is the reason why we rely on that, because saying on the character of the person, the court ascertains whether to rely on such person's statement or not. uh, while doing the cross examination, it is not allowed to while doing the examination itself, it is not allowed to ask leading questions. Okay, section 141 of the act feeds that the witness with responses and must be objected to the opposite party when asked by the witness for any kind of leading question. Section 142 say that leading question may be asked in examination of chief. So why can be asked in examination of chief, but in cross examination you can't ask any kind of leading questions. Even in re-examination, the court can permit any kind of leading questions. The section also states that any kind of leading question can be permitted by the court in case where the facts or undisputed or those in the opinion of the court have already been sufficiently proved. In such a situation also, the court can permit. Every statement given by the witness must be recorded in writing, and he can on later stage be cross-examined and be contradicted on his previous statement. So whatever statements are made during the chief examinations are reduced to writing, basically because of the purpose, so that such can be contradicted while the cross examination of the party is done, the witness is done. Also, the court also has the power under section 151 to forbid certain set of questions which the court deems are indecent or scandalous. Such questions shall not be asked. Question shall not even attack the witness's character. For suppose a question is asked during the examination of the witness, it should not be asked merely to shake the credit or injure the character of the witness itself. As per section 153 of the act, it states that any question can be asked and the witness has to answer it only, but if it only causes injury to the witness character, no evidence shall be given to contradict him in such a situation, unless he answers falsely, in which he will be charged for giving a false statement. But there are two exceptions to this situation. One is if the witness has been asked whether or not he was previously convicted. Second would be if the witness has been asked the question that impeaches or is impartiality or denied the witness, he may be contradicted in that situation also. It means that the party has sufficient grounds to believe that the witness is not impartial. They may contradict him to furnish to just furnish proof on that. So under section 165 of the Indian Evidence Act, the judge has the power to pose questions in order of production of the evidences. However, the judge cannot compel any witness to answer his question, or his decision should not be solely based on his questions only. The decisions must be based on the relevant facts and the evidence produced before him. So therefore, the judicial interpretation have brought significant and positive changes in the act to meet the needs and the time that have been made for the more practical or based on more practical approach for dealing with the witnesses itself. So this is the very basic approach of that is followed by the courts while examination of the witnesses. I hope this was helpful. Thank you.